Down, so she's laying down right here in the brush.
All right. Joliet Police K9! Amanda, in the one line. You are under arrest. You are under arrest. Make yourself known right now. We're going for you to search. He will find you and he will fight you. Last chance. Surrender now. Joliet Police K9. Here. Amanda, the dog's in there. Get your hands up. Get up. Got her?
All right.
This footage raises four distinct constitutional questions under 4th and 14th Amendment doctrine. The first is the lawfulness of the seizure itself, governed by Terry v. Ohio. Terry permits brief investigative detention only on reasonable, articulable suspicion of criminal activity. Mere presence in a retail store without more does not satisfy that constitutional threshold. Here, the suspicion arises not from the officer's observation, but from store employees reporting concealment. Under the collective knowledge doctrine, that information lawfully transfers to the responding officer.
Where are you going? Stop! You're under arrest!
Well, it's funny I'm out with the female at the Walgreens.
No, please. Please.
Stop her now.
Please, let me go.
Stop resisting.
Please, let me go.
You're under arrest
Please.
now.
Please let me go.
Okay, you're under arrest.
Please let go of my hand.
Oh, stop.
Please.
You are under
Please let me
arrest.
go. Please let go of my hand. Please let go of my hand.
Stop right now. You're resisting.
Please let go of my hand.
I'm not letting
Please let
you
go of my hand. Please.
Stop. You grab me.
Please let go
You
of
are
me.
going to jail.
Please.
You got nowhere to go back here. All right, let's go. I'm going to get you on the other side. Let go of me.
Please don't. Please.
My backup's coming, and you're going to get tased.
Please don't.
Stop right now.
Please. Okay. All right.
Stop.
Okay.
Hands up now. Hands up. You're under arrest. You understand me?
Can't put my other hand up.
Don't put your hand up.
Flight then triggers Illinois versus Wardlow, decided by the Supreme Court in 2000. Wardlow held that unprovoked flight in a high-crime area can supply reasonable suspicion. The officer articulates this doctrine on camera, demonstrating contemporaneous legal awareness. The second question concerns the moment of seizure under California versus Hodari D. Hodari D holds that a seizure by show of authority is not complete until the suspect submits. Until physical apprehension in the brush, the subject remained legally a fleeing suspect. That distinction governs which force standard applies and at what point in the encounter.
Oh.
20, Walgreens, Ingalls and Larkin. Female bit me.
And in a few minutes, the officer will find out why this is a huge problem, specifically in regards to the sketchy profession of the female and what she is known for in the local area.
She's in the wood, tree line here.
We got units around. 22 on my black and Larkin. Hold on, I'm almost there.
You're gonna get tased as soon as you get out of here.
20.
Give me a unit. Yeah, she's in there somewhere. Female white wearing a white hoodie.
Female white, blonde hair, white hoodie.
Ma'am, you are surrounded. You are under arrest. Come out with your hands up.
Oh, no! The K9 is coming. You're gonna get bit. You better sound off right now. Get your hands up.
Come on out. I hear you. Hands up. You lost. You just made matters worse for yourself. Come on out. She's definitely in it. She didn't jump out. She wouldn't be able to jump out that fast.
160236.
That's where she jumped over, right there to your left. And she dunked down over here. Can we get a unit to the north side of the building? She dropped her purse. Probably has the merchandise in it, maybe an ID. You are under arrest. Come out with your hands up before you make it worse for yourself.
The third question is the use of force analysis under Graham versus Connor, 1989. Graham requires objective reasonableness measured by three factors balanced together. First, the severity of the offense, here misdemeanor retail theft, elevated by an alleged battery. Second, immediate threat. The subject was location unknown after active resistance. Third, active resistance or flight unambiguously present throughout the encounter. Reasonableness is judged from the officer's perspective at the moment of decision, not in hindsight. The fourth question is K-9 deployment, governed by a line of Federal Circuit cases. Vatican versus Prince George's County requires audible warning before releasing a service dog. Lowry versus City of San Diego treats the warning as a key factor in objective reasonableness. Kuha versus City of Minnetonka recognizes K-9 apprehension of concealed suspects as lawful. The handler delivered a textbook bark and announce, identification, consequence, last chance. That procedural format is precisely what federal courts have endorsed in Section 1983 claims.
One got bit, right?
I got it.
You got bit? Yeah. Okay. You just take your coat off in there just to make sure.
Lady bit me. Yeah.
No way.
Comes back to Samantha Bravado out of Crystal.
No, where'd you?
It's Samantha, she should be 99.
She didn't break through her skin at all.
Right here.
Okay.
At the 2 marks
Yeah, she
there.
should be 99 in the county.
Yeah. She didn't even really break skin. Sarge said she's a
25 up to
prostitute.
23.
So
The west place from
Oh, come on.
That's what he said. So the big thing is just make sure you clean it. And she didn't break the skin, which is a good thing.
little bit of blood, but
I would say, yeah, because that's disinfectant, so that would be your best shot right now, just to keep it clean, try and kill it. And then, yeah, the big thing is just, yeah, awesome, man.
they thought she was stealing. I was talking to them inside about some other case, and she just slid out, starts running. I'm like, well, that's good enough for me.
Yeah.
Chased her, jumped over there.
So she's hiding out there somewhere?
Yeah, she's in the
Wow.
You saw her jump this fence? She jumped right over here. I held on to her as long as I could, so she then she went, tried to get to the other side. I ran around, she never made it. And she tried to crawl and duck down, so she's laying down right here in the brush.
Alright. Joliet Police K-9! Amanda! In the one line! You are under arrest! You are under arrest! Make yourself known right now! We're going for you to search! He will find you and he will fight you! Last chance! Surrender now! Joliet Police K-9! Here! 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 Samantha, the dog's in there! Get your hands up! Get up! Get up! Got her?
All right.
Good job, guys.
First, before I go, I know I'm going to regret. I have to go to the hospital.
Get on your toes. Get on your feet.
I'm sorry.
Is she already crying for an ambulance?
Yes.
Yeah.
14 today. Social back.
Stand up!
Just put the stuff in her bag. Merchandise? Yeah. Well, they're going to be good here. I'm going to go and put the bag. Yeah, I'll get the bag. I'll get it.
There's her stuff.
Thanks. She bit me. Yeah, that's alright. Yeah. They wanted you to show up even though I was in the...
Okay.
Yeah, I can't, like, I've dealt with her 1,000 times. I've never known, like, she punched me. But, yeah.
Can you get him to do a show up?
Yeah. I'm gonna do it, though. In the car.
Alright.
You alright?
Yeah, she barely cut the skin. More pissed off than her. She bit me.
And for the items she stole and fled over, well, these are them.
Yeah, she saw you and she just took off from it, right?
I tried leaning in to see if I could see anything. I couldn't see anything. You guys didn't have her or anything. I didn't have anything. And, but running in the high crime area is enough to to go after. So can you just see what is yours? Yeah. I'll get a property theft log.
52 come to the rear of Walgreens.
You want me to at least handle the retail theft portion? You just handle the like.
No, it'll be all together. So.
You okay?
Yeah. Can you grab me a retail theft?
We're headed over there now.
That's not sure. What's up, man? You good?
Yeah.
I want to see.
Barely broke the skin.
Yeah, you probably gotta look. Still gotta look at it. Sure, dirty.
They looked at it and said just clean it up and that's all I need.
Okay.
And then they documented for whatever on a report. Just.
All right. As long as you're good with that, now we can get you some. Swing up there. Okay. I'll try to see that shot. Can I clean it up for you?
Yeah, well, we put some antibacterial stuff, yeah.
What, was she stealing? Was that the problem?
Yeah, so I came in here to talk about a different case, see if they had video from a different case. They told me, hey, good timing, this lady, her purse is getting larger and larger and larger.
Sure.
They didn't see anything taken for sure, so I stood by the register, figured I'd deter, tried peeking in her purse as she was trying to check out a few items she had.
She didn't agree with that?
Then she just slid and then just booked it. So I took chase.
As long as you guys are good.
Did she have pants when she was in here?
That's what I was holding on to for dear life.
No. I said, the old pants in the bushes street.
Well, I'll see you guys down at the station then, just whenever you're done.
Alright.
Oh my goodness.
Right place at the right time, or the wrong place at the wrong time.
When's the last time this dude chased somebody out, got bit?
Oh, no. I'm too big to be around. Damn, you're done with all the crazy people every time.
No judgment. Just asking questions, that's all. You know. I've arrested this woman so many times, and the last time I arrested her, she literally gave me a fake, like she gave me a fake name, right? But like when I walked up to her, I was like, hey, what's going on? Samantha? Like, that's not my name. I'm like, oh, I'm so sorry. I genuinely felt bad because I thought I called her wrong name. And then later on, I'm like, you asshole. Like, you had me really thinking that I called you out your name. She's like, I know more. Like, that was so stupid. Like lie to him. He's never met you.
Yeah. I think you're like giant rocks or something crazy.
Crack. I don't think that's anything like crazy.
Massive rock.
Massive crack addict. Gonna test it?
No, absolutely. Looks scratchy. I got tender lips.
Whoever's behind me, I
almost crashed.
So this is all we're looking at pretty much. Is this yours or is this yours?
No, that's hers. And then, yeah, she actually bought that.
Did she buy it? Because
Yeah,
she was in the process.
Yeah, she bought that
at the pharmacy.
Yeah, and then she was walking around with that bag. And that's what she was
Thomas?
Yeah, it was,
How about these?
Yeah, those two. Yeah, she bought.
Is this yours too or no?
Yeah, that's ours. Yeah, she bought the telephone and the syringes.
This yours?
That's hers.
So was that maybe $40 worth of stuff right there?
Yeah, she definitely bailed on. We found some stuff over that she didn't leave the store with. So she must have saw him and...
A separate 14th Amendment concern arises from on-camera status-based commentary. Equal protection prohibits enforcement decisions driven by protected status rather than conduct. Casual characterizations recorded on government equipment are discoverable in any subsequent litigation. Such statements may be admitted at trial under Federal Rule of Evidence 601 and beyond. The aggravated battery question turns on whether the bite broke the skin under state law. Most jurisdictions require actual physical injury for felony enhancement of battery on an officer. The Bodycam itself is the most reliable witness to that contested medical fact.
Just immediately was like, okay, put some of this stuff back. Then she bought like a few items to the register. It was like a data.
She was acting like weird. We were watching her for like 20 minutes. I dealt with her. Right?
Yeah.
She didn't break the skin or anything?
She did a little bit, but they...
I would go get checked. You know what I mean? Like...
they were saying it wasn't...
Your hand, not them. You know she's a well-known prostitute.
How well known?
She's advertises.
Oh, I was just asking how.
Is that right there?
Yeah.
That's broken skin, man.
Yeah.
Cool.
Yes.
Can you call 17 see if there's another way in?
You got everything to lose and nothing to gain, so might as well go. That is broken skin.
Yeah.
I'm sure I can handle the retail theft for it straight. Do a follow-up.
Yeah. Dude, why don't you do that and go straight to the hospital? Get that moving.
Do I got a quick follow-up?
Do you have a body cam, or is that an extra holder?
That's an extra holder.
Okay.
I got an extra body camera at the station. Because I probably drive to different places.
Yeah, you should probably do that.
Yeah, it's up to you.
Alright.
It's for the best, man.
Yeah.
I mean, get a tetanus shot, you know, at the very least, get a tetanus shot.
They'll give you a lollipop.
Alright. I do want to go with the PCS too.
Yeah.
The pursuing officer earns a C+, legally literate, but professionally inconsistent on camera. The K9 handler earns a B-, limited only by facts not visible in the available footage. The subject earns a D. Every legal protection she had remained available in court, not in flight. The department grade remains incomplete, pending review of written policies and training records. 3 lessons emerge for both law enforcement and civilians from this encounter. For officers, the camera is always on, and informal commentary survives in litigation forever. Repeated audible warnings before any K9 deployment are the single strongest legal protection. For civilians, flight from a lawful detention only multiplies the charges and the force authorized. The proper remedy for an arguably unlawful stop is the courtroom, not the tree line. And for departments, foot pursuit policy and bodycam discipline must be trained, not merely written. Let us know if there is an interaction or legal topic you would like discussed in the comments below. Thank you for watching, and check out our second channel for more legal analysis.